Forum so we can officially start our quarterly DRAC meeting. And my name is Brian, and I think everybody knows everyone. Talia may not, so if she wants to introduce herself, I think is the only staff person we haven't seen before.
Sure. Hi, everyone. I'm Talia Concrevis, she, her pronouns, and I'm the Assistant Director of Homeownership Programs and Acting Director of the Homeownership Division right now. And just a warning, I'll be in and out because I have a few overlapping meetings, but I wanted to listen in on this meeting, and I've been learning a lot about all your work and yeah, so thanks for letting me pop in.
Yes. And then I know Patrick had some public input that he wanted to share. If
Is now the time, Brian?
now is the time.
All right. Well, great. Thank you so much. It's good to see everyone this morning. I put it in the chat, but I just want to highlight that Heather's on her way. She got hung up at court this morning, and so she will be here shortly. So what I wanted to share this morning just briefly is, I review a lot of data to help inform policies and make sure that my positions and such are grounded in evidence. When I'm going through all this data, I like to take moments to remind myself that each of these data points is a heartbeat. Each of these data points is a family member and a valuable member of our community. So I wanted to just take a brief moment to share a recent mediation case that illustrates how mediation can shift a situation from one that seems like it's headed towards eviction to one that's focused on understanding, problem solving, and preserving housing stability. And so this particular case involved an older woman who had lived in her mobile home community for many years, and she was suddenly finding herself at risk of losing her home. And the situation wasn't caused by her own actions, but was concerns about her partner's behavior, who had struggled with alcohol use and had sometimes acted disrespectfully towards other folks in the community, including a staff member, a maintenance worker of the community. And so during the mediation, she spoke very candidly about what was at stake for her. The prospect of eviction was extremely frightening. After years of building a stable life in this community, she couldn't imagine starting over somewhere else. And she was really, really worried about where she would go and whether she'd even be able to find another place that she could truly, call home. And what followed was not an argument over positions, but it was really a conversation about people and about their circumstances. And the property manager took time to listen, not just to the details of the complaint, but to the real fears that was behind what the tenant was expressing to him. And as he heard her concerns, he really began to better understand the impact of losing housing would have on her, this particular tenant, and particularly at this stage of her life. And so the conversation created a space that was about problem solving. Together they explored options that would address the management's concerns about the partner's behavior and allowed her to remain in the home. And the discussion also allowed for her to advocate for her partner to be able to have that opportunity to find support and make changes that would help prevent those future problems. And so this structured conversation that mediation offered really helped to slow things down, allowed a space for each other to truly listen to each other and work together so that both parties felt heard and respected. And that mutual understanding is what made it possible for them to be able to move through and beyond the conflict and focus on a solution. And in the end, the outcome was much more than just avoiding an eviction. This longtime resident was able to remain in the community that she called home. Management's concerns were addressed, and everyone left, with a path forward. And what I like about the story is it really just illustrates the power of mediation to transform that conflict and put it into a constructive dialogue, help preserve housing stability, and create solutions that really honored both the accountability of those actions as well as could touch on the compassion of the humanity of those involved. So just wanted to take a brief moment to share that story as we talk about policies and data a lot in this room, and just wanted to share that humanity. So just thank you so much for giving me the opportunity to be able to share those experiences with you all.
Thank you, Patrick. And yeah, I'll just add that, yes, and that one of those pieces is that confidentiality that mediation provides that allows folks to have a different type of conversation because it won't get used against them in a court or other setting trial piece. So thank you. Any other public comment or requests from Cindy or Shana that were received? Okay. With that, we can move on to review and of the minutes from our last meeting, April 1st. And do anybody have input, corrections, changes?
Brian, I've got one
Okay,
on page 5. Before I do that correction, just let me say that these minutes were very detailed, and I think that was very helpful, or will be very helpful, especially in trying to understand the budget situation going forward. So what is that sign to me? Oh, okay. So on page 5, under legislative update, in the first bullet, it has me talking about the 2026 session. And on about, let's see, 5 and 6 lines down, I was quoted as saying accurately that the Legislative Revenue Office does a report toward the end of each session that the legislature then uses to figure out how much money is needed. That's not what they do. They tell you how much money is available. Revenue. It's projected revenue that LRO tells the legislature. So then the legislature knows how much money they have to spend. So I would prefer to change needed to available. That might be my mistake and not the minutes recorder, but I think it'd be more accurate to readers to say how much money is available. With that one change, I would move approval.
do we have any other corrections? If not, would someone would like to do a second?
I'll second that.
Bill has a second. All in favor of approving the April 1 minutes? Symbol by raising your hand or virtual hand if you're on the phone. It's like we have unanimous passing of the minutes.
I
Well,
just
thank
want to,
you.
I was been emailing Heather and she said she's locked out of Teams. I think it's been an issue in her office, so I'm not sure if anybody has any ideas. I think she's going to call me.
So I was out of it. I had to call our computer people to get into this meeting.
Did they share the fix that worked or?
Okay.
He said the browser was the problem.
So possibly if Heather tries joining on a different browser, maybe. If she has that option.
She's on the phone right now, so
Okay.
I'm letting her hear you.
Okay,
So it's a I mean,
Pat just shared that she had a IT issue in that and her folks said try a different browser and that corrected the issue for her and she was able to join under a different browser.
so maybe go in private mode.
And if not, we still have you by phone in that.
Okay, sorry to tell you for that. Lincoln.
And if that, well, you're working through that, Rick, if you want to share on the update on the registration fees?
That's still is a legislative concept. It's been still being worked on and still trying to determine exactly what amount we're looking at. And so no news yet. And as far as what we're going to be submitting.
And with that, and do you have that timeline as far as submission? I know Nathan.
Well, I know we have to submit it by September, so
Okay,
that definitely should have something more concrete for you guys.
So Brian, could I ask Rick a question?
yes,
This is John. So Rick, I wasn't, I didn't attend or watch, but I understand that HCS made a presentation to the governor's office with regard to what's referred to as the GRB, the governor's recommended budget. Can you say anything? I think that was last week, and I've heard from a couple of people who did see that about it. And I understand that at that presentation, you all included information about the possible funding strategy. Can you say anything about that?
No, not really. I mean, I know that it was submitted, but I don't think any decision was made on it at this point.
So I do have more to say, but I'll save that.
Oh, go for it if you want to. Please do.
Okay. So Nathan has provided, at her request, Representative Marsh, some financial information with regard to the status of MMCRC's budget. It's fairly general, but it does indicate a deficit for the 2023 to 25 budget for MMCRC, and a deficit, even greater deficit for the current biennium 2025 to 27. To me, the significant words in Nathan's material that he shared with Representative Marsh were that this is not sustainable. I think that's a starting point for any budget discussion. I think more information will be required, both to persuade the interested parties. Again, one other piece of information: there's no general fund money in MMCRC for its operation other than the replacement program, which is a Representative Marsh created program that provides for funding to replace older manufactured homes. But there's no general fund in the rest of MMCRC's work. And Shauna gave us a lot of material last night, one of which listed all the things that MMCRC staff do, which I think is an important thing. Given that there's no general fund in that, the money will have to, either services will have to be cut or funding will have to be found otherwise. And the two otherwises that so far have been funding MMCRC are the tenant special assessment and the landlord registration fee. The landlord registration fee, I don't think produces a whole lot of money. It's $50 for smaller landlords and $100 a year for larger landlords. I think it's less than $100,000 a year in income, in revenue to MMCRC. And then the tenant special assessment is quite a bit more. And it was created in 1989 at $3. It was created at the request of OSTA and Patchwork at the time, because they wanted to have some services to help educate landlords and tenants and also help resolve disputes. That $3 fee was increased, I think, in '99 to $7, and then 2015 to $10. And it's currently the $10 that's paid, and it's paid with their property taxes. There are a couple of counties where, the four biggest counties, where low value manufactured homes are waived from paying property taxes because the cost to the county to collect the property taxes was greater to the county than the amount of money they got. And so those manufactured homes with a low value, quote, low value, which is indexed, increased, I think it's somewhere around $30,000 a year now, or $30,000 valuation for the home now. Those manufactured homes don't pay the special assessment. The question would be whether to increase the special assessment on tenants and whether to increase the landlord registration fee. And let me note, been saying this like a broken record, though both of those amounts were created with the support of the taxed party, the tenants or the landlords. And to my view, increasing those without the support of that party will be difficult. So I don't believe that anybody's begun any discussions with that. I'm on the OSTA board. I do brief the OSTA board about these things, but I don't think I know that the OSTA board has not taken a position. I have no idea whether MHCO has taken a position or will take a position. And I don't know what the status is of the other landlord group OAPO. I always get that wrong. OPOA. And I note that's on the agenda. So that's a little background I think that's important for you all to know.
If I could just add to that, one of the things on the assessment per manufactured home is once we collect all those funds, we also have to turn around and pay each county $1.50 from each from the $10 collected. So I'll just, for instance, if I just use a round number, if we collect $600,000, then we pay back a portion of that. We end up somewhere around 400 and something thousand. But just to kind of add that, we don't collect it, even though we collect it, we still have to pay something back. So we net out of that. But just wanted to add that part. And I think Pat had a question.
John, I want to ask you a question about property taxes and manufactured homes, but it doesn't have to happen now. It's a long held question. Because it may not be appropriate to this thing. I wrote a note, so I remember to ask. Right here.
Great, Pat. And other ones, for those who joined late, Nathan is at a all-day retreat today, and so is not going to be joining us to share his perspective.
Brian, Bill has a comment as well.
Oh, yes, Bill.
Oh, thank you. I was just going to respond to John's question about MHCO. As many of you know, I'm their legislative counsel on, and so work a lot with and closely with them. They don't yet have a position on this, John. I think, understanding what the proposal is would be helpful. And also, I'm happy to chat with anybody as it's being created. I think overall, MHCO, supports this program and supports mediation overall, and is sensitive to the funding challenges of these programs. At the same time, we're trying to couple with conversations with our members about continued limited rent caps and whatnot, and then government mandates on top of that. So it's a challenge for us, but I'm happy to engage in that conversation.
Angela?
Yeah, just generally, I know that these services are really, really valuable to tenants. I'm sure the people who answer the phones at MMCRC can attest to that. My understanding is that the vast majority of users of these services are in fact tenants. And a lot of the services that MMCRC provides is to help educate landlords about what the laws are and what tenant rights are. So I think it's a very, very valuable service. I do just want to point out that, times are getting tough for everyone. Bill mentioned landlord expenses. Yeah, I totally understand. I understand too that when tenants pay this assessment, it's the difference between, food in their mouth and medicine and other things just to arrive at some sort of justice, to exercise the rights that they already have, that we've already voted on and agreed to as a community. And that typically an assessment for a landlord would be a business expense. So there is that just differentiator. So I don't know what the answer is, but I just wanted to point out that it's tough for everybody, and the services are needed greatly.
Thank you, Angela. Any other input or comments? If not, we can move down to Ken on the follow-up from the discussion last meeting about the non-compliance process and that, and also Ken Bunett, once you finish up that, I'll let you jump in and do the landlord training piece, just so it's consecutive.
Okay.
The floor is yours, Ken.
Sure, I'm trying to bring up the non-compliance statute. Let me see if I can share it. How about that? Can you see that?
Yes.
Okay,
Yes.
so I got a thumbs up. So it's as we discussed and talked in the last meeting, it's innocuous that there's no reference to any CDRC, etc. And there's a little blurb that basically says that if you've got multiple parties, to please add another form. That's the long and short of it. It's pretty straightforward. So, pending the determination of when a mediation actually begins, I've held off from issuing anything to the parties concerned. And as far as OPOA is concerned, actually they received a lot of funding from IPG. And IPG decided to terminate their relationship with Charles Greff, and that was that. They basically had resources that they thought they could deploy elsewhere, and that's what they did, and that was received by Andrew Fritz. He is the lead attorney for IPG that gave me that information.
And Ken, could you share what those acronyms mean?
The acronyms for
The
OPOA.
OPOA and the last one that you were just sharing, as far as the
IPG.
landlord training.
Income property group.
IPG, well, I can't remember what their
Income
nomenclature
property
is.
group.
Okay, yeah,
John's
and
the
they
same
have
thing.
about, I'd say, close to 50 parks in the state.
And
It's a
IPG is not going to do any landlord training.
Oh no, they always used OPOA as a proxy, basically.
And so is there a concern as far as being able to sustain that training offering, or?
We're exploring opportunities more recently with CETA, the Springfield Eugene Tenant Association.
John?
So I'm confused. IPG used to fund OPOA, and now IPG is no longer, and I should note, in my experience, OPOA was mostly California entities that own parks in Oregon, often corporations or groups that own more than one park. So they're sort of like a competitor with MHCO that Bill represents. And in my view, liked me even less than MHCO did as a tenant advocate. So it wouldn't be a problem for me if OPOA went away. I'm curious from Bill whether MHCO is seeing members from OPOA move over to MHCO. Regardless of whether they fund OPOA, I mean, IPG funds OPOA. The IPG and the former members of OPOA are still going to be required by statute to get landlord training.
Exactly.
And MHCO continues to offer that. And so IPG could just do an MHCO training. But Ken, is your understanding then that OPOA no longer exists?
That's my understanding. They severed relationships with Charles Greff.
Interesting.
Bill?
I was going to say that's my understanding as well, is that OPOA no longer exists. To answer John's question, I've asked Chuck that question of whether or not we're seeing OPOA members or former members come to MHCO, and I don't have an answer to that. I'm happy to report back. I do know that just in my personal experience is that the number of attendees has been increasing at the various MHCO training. So, that may be indicative of OPOA membership coming over. But it's also just a good sign that, folks are taking their obligations seriously.
The other thing that I've noticed is that many of the tenants or landlords that are taking MHCO courses, they've truncated their compliance. They're taking training every year. So that's one reason for the bump, and it's been significant.
It's Angela. I have one question about this program that I've always wondered. Is it possible for tenants to attend these trainings, these landlord trainings, on a complimentary basis, not having to pay for the session? I mean, the training is to train landlords on the rights of tenants. I don't think it's out of the realm of possibility to think that it would be a good idea for some tenants to sit in and learn what the landlords are learning as well.
Well,
It doesn't say anything in the statute that tenants can't attend.
Yeah.
Right. I'm just saying it's a pretty hefty fee that these companies like formerly OPOA and MHCO are taking in to attend the training. I think somewhere north of $200 or $250. Is that correct?
Somewhere 100, I think. Oh, I don't know. Bill, you know.
Yeah, I don't know the cost, Angela. I do know that, these trainings are also used, I think, in the fees to, pay for the content, which is for the experts to actually do the training, and also to essentially, keep these organizations in place. So, I'm happy to bring that up with, with MHCO, Angela. I think that, or whether there are opportunities for, a collaboration of maybe some landlord and tenant lawyers together to do trainings that are, very landlord and tenant specific, kind of go to both sides. I mean, the landlord side is a, really focuses on what landlords need to focus on. But of course, it would be helpful, I think, for tenants to hear that. And likewise, I think it'd be helpful for landlords to hear the other side of what some tenant advocates might be discussing. So happy to have that conversation.
Yeah, and maybe, in looking at the revenue from these, I know that MHCO, they take in quite a lot of money. It's publicly available in their tax filings for these educational programs that they develop and charge money for landlords to attend, given that it's written into the statute and we voted on the requirement of these classes. So what I'm just asking is it possible from those profits that perhaps a handful of tenants could attend each session if they so choose?
And I think, yeah, that is that little
Pat, did you have something?
outside, but I within our scope, I guess I'm curious, is this going to impact the availability and the timing for new park managers to complete that training requirement that's in statute? Or
MHCO offers, what is it, every 3 months? I think we have them. We checked in with them, and I know it sounds like Ken's looking at other options, but they're 90% on Zoom. I think there's just one that's offered in person. So,
and let me add that, Brian, that the statute addresses timing for new managers.
right, that's why I was curious on availability of training.
Well,
So, I mean,
it's easily 3 times a year.
Pat, did you have something?
So there's trainings that are offered during the year that start maybe in March and go to the beginning of summer. And then in the fall is a 2-day conference. part of that 2-day conference is the required training by law. And part of that conference are, let's call it electives, related, of course, to manufactured home parks. The meetings are, the fall meeting is on Zoom and in person if you choose. And the other ones, which are a 1-day thing, I assume that they're in person and on Zoom also. I haven't attended one of those in a while. I usually do the fall one. The 1-day ones used to be in person. I assume that it's still Zoom and in person, but I can't attest to that 100%. So cost would have to do also with the facility that they use, because though they aren't free. And with the professionals that come and do the training. That's not to say that I'm adverse to the tenants coming at all. It's, I know that even in person, when people have the Zoom option, that in person, when I go in the fall, that those are often full.
I just want to clarify, I just went on the website and I think the last offering is July 30th for the year. And then there's the conference. And then that's it for the year for MHCO for training. So I just brought this up because DRAC is over landlord training. I thought it was important just to make people aware of the situation.
So
Well,
the trainings, the 1-day trainings are about 4 times from about March to July. And then there's the 2-day one in October, 3rd week. And then you go through the holidays and it starts up again in the early spring.
Yeah, no, which I think is that piece. And so John, then Ken?
So I just want to note that I have previously been invited to attend and speak at MHCO conferences, usually or trainings, and usually I think at the annual conference, which is held in Eugene at the Valley River Inn. So that's pretty handy for me. But it was only at their invitation. And they've invited others, I think, over the years. For example, last October, they invited Representative Marsh to speak at their conference. It's a private group. I don't think there's any statutory requirement that MHCO invite other people who are not landlords. A lot of these sessions, they're talking about strategy issues that probably wouldn't want tenant advocates to hear, not to be adversarial, but our relationship is somewhat adversarial. And after HB 3054, it's probably a little bit more adversarial right now.
I also just want to clarify that my request for tenant participation was only in the landlord training sessions, not in the full conference. I understand that's going to cover a lot more things. I did ask Chuck Carpenter, Executive Director of MHCO, to attend one of his landlord trainings and was ghosted after he did offer that to me in a meeting. So I wrote many, many times to seek attendance. So I don't know that it is open.
Yeah, and I think that's going to a little bit outside the purview of this. I was more concerned about new managers being that on-site folks seem to change over fairly frequently of access to that training. And so sounds like as of right now, it's not an issue. Ken?
yeah, I just wanted to let you know that typically training starts, this year it started in February. And typically you'll get, from February through July, you'll get 2 or 3 sessions out of MHCO. And then they start back up again in September. Mid-September, they start back up again. So there shouldn't be an issue of overcrowding or not being available for landlords. After all, it's every 2 years. But as I said earlier, that many of these property management groups have taken to doing training every year because, things have been fairly fluid. But I see that as a real, a positive sign as people wanting to understand and participate and understand statute. So,
And is there a tracking that your office or Ken or Rick you do for that training piece of the I
Do
Yes,
we-
see Shauna nodding yes. And
We track it, yeah.
Yeah.
And
Yeah,
it's
I
on the
mean-
website. People can look themselves up to see when they're next due.
I also wonder too, I just checked ORS 734 that references manager training when you have a new manager, and it says that the statute says that that new manager, if they haven't previously taken the training and have come on board as a new manager, that they should take that within 75 days. So if the 75 days is that period that's allowed, what happens if they get hired on August 1st?
Well, it says 75 days or as is available, I think. So it's got some latitude there.
Oh, the next regularly scheduled continuing education class, or by taking okay, I see.
So you get this, and it's filed with the state. You only get it if you turn in your name tag at the end, at the very end, because that means supposedly that you've stayed because you're there at the very end to turn in your name tag.
there's a strategy of that, so we could move forward. Is there any action item we need with this as far as just to monitor, and if there's any, if you become aware of any delays or people not getting the training, that you would let us know that as a committee and can make a formal recommendation or action if that occurs? Future meetings, and with that, we can move on to Shauna for the majority of the rest of the agenda.
Oh my gosh. Okay, I'm going to share my. I just tried to here. Sharing, hitting share. It's very slow. I don't know what happened there. Okay, here's first the survey. It's great. Everybody got theirs in. This is third quarter. And everybody received it. I don't know if anybody has any comments. I also did this. Everything's very slow. Just to show the numbers. Just look good. I mean, I think this is what the legislature would want to look at. Mediation resolved, how many people, how many mediations. And all of you received this. So were there any questions? I'm going to stop sharing. So
Is
that's it
Tilla-
for now. Yes.
Is Tillamook not involved?
They just haven't, I think they had one case. Let's see what they put.
It's blank.
Oh, it's blank. Yeah. The ones that haven't, so Tillamook, East County hasn't had any, and Eastern Oregon hasn't had any. So, and then there's a lot, I mean, we can look at all of that of like area, sorry, I was just looking, I realized I wasn't sharing it with you anymore, but do you have that, Pat, if you wanted to look at it?
Yes.
Tillamook did turn it in, and then you can see how much, the funds they received, the CDRCs, was based on numbers, I guess, from Patrick and just kind of what it looked like they would need. We are evaluating that for 27-29. If it is like, we're paying people CDRCs $7,000, $8,000 for 2 years and they're not doing any manufactured or marina mediations. So that's it. We can move on to the next if people don't have questions.
And with that, we'll be adding the next quarter, and that may be helpful to look at a whole year if there's a bigger.
Right. We only
Yeah.
have 2 quarters.
Yeah.
So, what's the next thing on the agenda? You want to talk about the website?
The next thing was the website.
Okay, so it was taken down because it was a PDF and we were supposed to put it back. I think it's a pretty helpful, and the plan is James is the communications person for OHDS for homeownership, and we're gonna make this a website along with the flow sheet. He's working on it right now. He's not here today, but so I don't know, was there anything else you wanted to talk about it, Brian?
No, I think it was more just recognizing, and I know we had, as a committee, had put a lot of time into getting this created so that it was gone, and just wanted to share
sorry
out with
about
the
that.
larger committee why and what the plan is. So perfect.
Yeah, and it was an oversight. Sorry that we had to take down all the PDFs. We had a whole bunch of PDFs. And so we made a lot of them, but that was one I was going back and forth a lot with James, and I think that was one that was missed. So yeah, and then as well, the flow sheet will be added. So
is it just English? Are there other
oh, we had it in
languages?
Spanish. We have it in Spanish as
Yes, I have
So
a
we'll have
Spanish
both.
one.
Yeah, we did have that one translated, so that was why it was unfortunate we had it taken down.
And the great part is when it goes to the website, then you can translate it into any language.
Oh yeah, that's true. But we did have our internal language department translate it. So we do have that as a PDF. I mean, that's the thing. If you would want handouts, I don't know. We've never really gone into that, but if landlords wanted handouts or tenants, we could email it to them, I guess, as a PDF.
I've included that in my application packet. And I have a packet in English and a packet in Spanish.
Oh, that's great. Okay, good. I'll send you the most recent just to make sure you have it, Pat. Is that
Okay.
if that would be helpful? Yes. Yeah, I think people like to have hard copies as well. So we definitely have that available. We just can't mail it to them, of course, but we can definitely email a PDF. Anything else about the website?
Don't see any questions or comments, and so that takes us on to the draft rules.
Yeah, so the draft rule for mediation right now, it's definitely in draft form. What happened was, we have many steps, and we had our rack, and we were going to have the public hearing July 21st. We were going to post it. We have a rules coordinator named Andrew. One final step is to have the homeownership director approve, which is Talia as interim. And she had a lot of questions. So we missed the deadline of June 30th. Whoops. So, but in a good way, we have a whole other month. So it's only once a month you can get it into this bulletin. So now everything's shifted to August. So I was going to send an updated email to everyone involved that you have lots more time to respond, and the public hearing is going to be in August. We haven't set the date, but that will all be posted on our administrative rules website, which I will also send that to you. But I didn't really think that we needed to discuss it. We're still kind of, we have a draft response from the DOJ. That was his response to our question, what's mandatory mediation? We got like 4 pages. So that was all we have. Oh gosh, sorry. I know. And I don't want to make it sound like Talia messed up our deadline, because it wasn't at all. I mean, we gave it to her like 3 o'clock on June 30th. So Definitely. And it's not timely. We've been waiting years for this, so I feel like it's okay to wait one more month. So that's it. I
Hey,
don't know if anybody else had questions.
Sean, it's Angela. I have a question.
Yeah,
Just help me remember and recollect. So I read through the two documents, one called the DOJ advice and one called Mandatory Mediation Rule Chapter 813 Division 007. So that second one that I mentioned the title of, that is the one that is in draft form.
Yes.
Okay. Yeah, do you want our comments now, or how do you want to receive those?
So we requested if you could send it in an email, because it's great to have them in writing instead of, but yes, and everyone, I didn't get any comments, so it'd be great to get some comments in writing about it. And really, it's definitely draft. What we were focusing on working with the DOJ was like initiation. We felt like that was the main issue, and more can be discussed. Yes, Rick.
Okay.
I just yeah, go ahead. Go ahead, Angela.
Oh, I just wanted to say, in case anyone else reads through that, the number 4 numbered bullet point on the rule document mentions delivering an email or letter. And I think for me, the whole purpose is to define when something is initiated. So then I think, well, what does delivery mean? Does that mean sending, receiving? Because statute notices only require sending, they don't require receiving. So I think maybe I just had a problem with that word being used.
Thanks.
So what does deliver mean?
Good point. Thank you. Definitely.
Yeah. And on that draft, have the comments from the attorney OJD been
the DOJ.
incorporated into that draft or not?
Yes, and it always seems like it's a lot of back and forth. Rick, I think we haven't sent the DOJ this draft. I mean, there are a lot of things that they say and then we take it out, and it kind of goes back and forth. So
yeah, what they do, sorry if I interrupted you, Shauna. I just sent that out yesterday, and again, we're still in that draft form, and excuse me, I'm sure Bill and John Maloney understand is we will use certain words, but then they say you can't use that word, and so that's where they come in to help us and direct us, so we're saying it correctly, writing it correctly, so it's understood correctly. Not that it's always understood correctly or clarifying, but we want to get their input on it so that we're doing it, we're writing it correctly, so that we're not running into certain issues of how we're using words. For the most part, they rely on us because of the work we do, but at the same time, they interject their thoughts and opinions on what they feel should be said and not said. But we also want to make sure that we not only get your opinions, that we definitely value them, but we want to make sure that we get everyone's opinion so that we can review all the comments and input, so that we can determine what is going to be best. The other issue is, or not issue, but just a concern that while we're putting all this together, please keep in mind that it's going to be impossible to include every scenario, every rabbit trail, because one will trigger another question, trigger another issue, and then this thing could be 15 pages long if we try to address every situation. So we're trying to be as concise and condensed, but still try to address the things that we feel is important. And that's where your input is the most important part of that, so that we feel we are covering things that are important to everyone. I hope that helps.
Yeah, if people have any other, just definitely email me. I think everyone has my email. So that's it for the rule for now.
Great. Any other questions or comments on that? And guess we'll be following up on that on the next meeting to see where it all lands.
Sounds good.
Anything more on the legislative updates, being that it's one very early and Nathan is not here?
So I can add a little bit more. So I think the funding issue is the primary, at least for me, the primary legislative issue for the 2027 session. I should note that as of today, I'm down to half time, and as of December 31, I intend to be down to 0 time. So I will not be involved in the 2027 session. But I will be working with Representative Marsh and other legislators to prepare for the 2027 session. There's no requirement that legislators tell me or my boss, Sybil Hebb, what they're going to do in any session, including the 27 session. We often hear about things because legislators know that we know something about landlord tenant law, and they ask us questions about proposals. The only issue that I'm aware of with regard to facility tenancies, besides the funding issue, is one from former representative, now senator, which makes when you're one of 30 instead of one of 60, you have more influence, and that is Senator Neron from Washington County. She arranged a tour of a park in Tigard with another representative from that area and a staff person for a third representative. I attended that. It was organized by Rita Lohberger, who was a former OSTA president and leader. And it largely had to do with, well, it had to do with a number of things, but the main concern has to do with the water pipes in that park. It's an older park. It's more than 50 years old. And some of the pipes are failing. And that includes pipes in the common areas and pipes in the in the spaces. The one problem is that, as I understand it, that there are only a couple of shutoff valves for the whole park. And it's a huge park, 150 spaces. I can't remember the exact number. So if there's a leak in one part of the park, the landlord has to turn off the water for, I don't know, 75 spaces to repair it. So, which is an inconvenience for all those tenants. But the bigger problem, a statutory problem, is that landlords' habitability duty, which is defined by statute, a statute that the old coalition negotiated and that I drafted, makes it so that a landlord is only responsible for water pipes to the space, not to the home, which means that pipes inside the space to the home would not be covered. Now, you can read that statute a different way, and I think Matthew Johnson might read it differently. I'm probably influenced by the fact that I know what was intended when the statute was written, which means absolutely nothing in court. So a judge would simply be reading those words and interpreting what those words mean. And you could make a reasonable argument that the way it's written does not limit the landlord's responsibility to the space. It could mean to the home. But the importance there is that if the pipe is leaking inside the space, and those pipes are underground, so they're under the space, then the question is whether the landlord or the tenant is responsible for repairing those leaks. Senator Neron is interested in that issue, and she may well proceed with it. She's sort of a can-do, charge ahead person. I'll stop there. There are other landlord tenant proposals, but most of them have to do with apartment tenancies and not facility tenancies. Although a fix in some of those may well impact manufactured home park tenants. They have to do with evictions for non-payment of rent.
Ken and Pat?
Well, just the statute makes exception for parks that are greater than 200 units, 200 homes. And in that case, the tenants are required or only responsible, rather, for what's inside their home.
So Ken, I wish you hadn't brought that up. That actually supports the argument. That supports the argument that the statute, the habitability statute requires only maintenance to the space. Because the argument then would be that the legislature knows how to distinguish between to the space and to the home. Because in the submetering, that what Ken's referring to is one of the submetering statutes, which were written not at the same time as the habitability statute. We wrote that one to make it to the home for larger parks that submeter. The background here is that at the time the habitability statute was written, the tenant advocates did not want landlords or managers coming onto their space to fix the pipe plumbing because they didn't want the managers looking in their windows. You know, in hindsight, that was a dumb decision. But that was the motivation at the time, and it was the tenant advocates' decision. Now, that means absolutely nothing to a judge. As I said earlier, the judge is going to read those words, and if a clever lawyer can convince a judge that those words mean to the space or to the home, then that's what a judge might do. Neeron wants to make that clear.
Pat?
So the city of Woodburn says that if it's the pipes in the ground, it belongs to the business. So in the house, it's the tenants. And that has to do with paying the water bill. If somebody's moved and the water bill's not paid. Now, people move and then their mail has to catch up with them. So people are actually really good about paying their last water bill. But before that's paid, we get a copy of the last water bill because the pipes to the house are in the ground. So it's the businesses. I always verify with the resident who's moved and the city whether it's been paid. For someone who died recently with no family, we paid that water bill. That's how it's worked here. We've been very lucky because the owners put in shut-off valves up against the house. Yeah, we've been very lucky.
Yes.
So clearly tenants are responsible for leaks inside their home. They own the home, they own the pipes inside the home. The question is pipes outside the home to the space or to the home.
Yeah, from the meter to the house, the city of Woodburn says it belongs to the business. I don't have a complaint with that. It's been easy to distinguish whose responsibility things are, looking at it that way.
And one other odd fact is that sometimes the meters, when a park is submetered, the meter could be in a number of different places.
Yes. Yeah.
This goes back to the original one of an asset sitting on top of an asset and the issues that arise from that. Circling back to the legal opinion, there were some possible next steps that was in that OJD document, or DOJ, excuse me, document. And I was curious what the plans were, Rick, or if that has been, because it talks about within your purview to define a form and some other pieces and suggestions. And it is something that I think would ties to the dispute resolution and our work as this committee, as well as where they're clarifying where they're supposed to be posted and those kind of items. So
that was kind of a long. So your question was, or is,
there's possible next steps listed.
Yeah,
in
yeah,
that
and we're
DOJ
still looking at all that and trying. What we're trying to one bite at a time type of thing. So we're, the biggest issues were when is mediation initiated, what is mandatory mediation, And then he had a lot of other things that we could look at and discuss, but we wanted to, just take it a step at a time as opposed to the shotgun approach, because then there's just a lot to cover. But so yes, we are looking at additional things, but at this point, not yet. Does that help?
That I guess was curious because like I said, it talked about OHS policy could also specify the required form of such notices as an example was one of their recommendations. And
yeah, one thing I found is when we get these, when DOJ looks at it, they have a group of 7 that look at what we ask. And so we're always going to get a lot of opinions back. And so they try to make sure that everybody's, the opinions of each of the attorneys are at least listed. And so that's why we always have to, the original question was, what is this? And then we get more from it. But we are looking at it all and seeing where we need to pay attention to. And at this point, we just are looking at the first couple things and what we've been discussing, and then we go from there.
If you have any feedback, can you send it to me, Brian?
yeah,
Like in
yeah, no,
writing?
it
That
was
would be
just
great.
like I said, they provided some feedback on that.
That would be great.
And I know I asked at times for having a policy guidance even on, number of attempts of what that is for the CDRC centers when they receive a request in that. And nothing, because we've had email explanations, but I've never seen it in the format of a official agency type policy or guideline that. And I think that is helpful, especially in the longevity as people change in roles and stuff, to have that one place to go to say, yep, this is what the policy is, versus trying to find an email from CanNet was sent to me and I'm no longer with the agency and trying to get those same questions answered. So
Okay, great, thanks.
other items for the order, our next meeting is October 7th.
John, I want to do real quick this property tax thing. In Marion County, at least, property taxes,
And Pat, I'm gonna
unpaid.
jump in real quick. Remember, this is a public meeting and I don't know if that's helpful and something you want
Yeah,
as a
no.
public record or not.
When I started on this committee, I had no idea that this was a public meeting. None, zero. That was a learning experience. But unpaid property taxes that are not paid for manufactured homes there's no collection. There's there's penalties, there's interest, there's all of that, but nobody goes out to collect, or whatever they do with stick-built houses. And so a person can pay no property taxes on manufactured homes until the house is sold. Most people pay their property taxes, but a handful don't. And then it's a hellacious experience. I think the county would be better served, among other entities, if they collected property taxes as they do for other places. That's just information regarding property taxes and manufactured homes in Marion County.
So Pat, what I would say is that first, I'm not an expert on property taxes. There are lawyers that specialize in that and doing assessment valuation appeals, for example. I've had some experience with it over the years, and mostly with regard to abandoned property, because when a manufactured home is abandoned, which is kind of an odd term, the tenants often don't simply abandon it. It's just that they've moved out of the park or died or whatever, and nobody's going to move that home. It's too expensive, and it's often not successful. And so we've got this incredibly complicated, long statute, which reminds me that I need to tell you all something else. But there's this long statute about abandoned property, and part of it is when it's sold, because some of those homes still have significant value. When it's sold, what happens with the property, the back property taxes? And so in writing that statute over the years, we worked with the county tax assessors in trying to figure that out. So my guess would be that that's a county choice as to whether to take an enforcement action. It's a lien. They could enforce the lien. The county could. They do in other settings. Typically, though, I think they don't do anything for 3 years at least, to let the back taxes accumulate for 3 years before they take any enforcement action. I'm not going to get involved.
Yeah, yeah. It was just information.
Yeah. But that does remind me that Rep. Marsh has had some discussion with tenant advocates about different aspects. One of those is the question of, quote, enforcement. And I should have said something about this earlier. Tenant advocates would like to see the state enforce landlord-tenant law in part with facility tenancies, as happens in Washington State. There's some good material in the minutes from the April meeting that talks about that. One of OSTA's newer board members, Judy Annan, is doing yeoman's work in trying to learn more about how Washington State does it. Colorado apparently has a similar program. And there's a benefit to the tenants in having the state do it as opposed to having, say, Samantha Sheehan as a free attorney do it. And that is that they don't have to get a lawyer and they don't run the risk of prevailing party attorney fees if there's a lawsuit and the tenant loses. I think Representative Marsh's view, and I shouldn't probably speak for her, but I think I've talked to her about it. I think her view is that's not going to happen in 2027. So if the tenants want to build towards that, they would have to build towards a subsequent legislative session, which could happen. I mean, that could happen. And I think Judy Annan is working hard on that. But in those conversations, Rep. Marsh was trying to talk about different issues that maybe the 27 legislature could address, because there's complaints from tenants that in the abandoned property process, some landlords take advantage. They improperly, unfairly, illegally discourage a sale by the tenant to a prospective purchaser. Over the years, there's been lots of horror stories about that. I think the statute already is adequate in addressing that. It's just a matter of enforcement. But anyway, Rep. Marsh, in looking at that, wondered whether there was a way to address what the landlord's sale of an abandoned home. And so she has brought in Rep. Levy from Bend, who is a lawyer and who has been very involved in foreclosure issues, to see whether there are issues that Rep. Levy learned in the foreclosure debate from 2 sessions ago, I think, or 1 session ago, that could improve the UCC sale of a abandoned manufactured home under ORS 90.675. So I don't know enough about UCC. I don't know whether I even passed that course in law school. So there may be something in the 27 session about that part of the 90.675. And I think Rep. Levy was going to contact maybe Bill and maybe some other landlord lawyers that know more about the abandoned property process than I do.
I'm speaking with Rep. Levy in the next week or so about this, and looking forward to the conversation. I have some ideas as well about how to streamline this process. I think one of the issues from the landlord perspective is that you often have 2 different types of homes that you're dealing with. You're dealing with often homes that have very little value and probably need to be destroyed or donated, and versus those that do have value. And I think that, and the statute treats both of them the same, which can be complicated. Additionally, I think that there's some issues about when the abandonment statute actually begins, and I think having a conversation about making that clearer so that I mean, there's an argument that an eviction needs to happen first. And I think that doesn't benefit anybody. So I'm looking forward to the conversation with Rep. Levy to figure out where we can work together on streamlining the statute.
So I think the intent initially was that homes valued at less than $8,000 are exempt from everything. But I will just note that it is maybe the longest statute in Oregon Nevada statutes. And I have always been very leery about trying to touch it again. One reason is because legislative council always ends up suggesting breaking it up into smaller sections, which just scares the daylights out of me. But good luck, Bill.
And so coming back around to this, anything else for the good of the order? If not, we can adjourn and everyone can get to a few more things so they can hopefully get to the 4th of July holiday a little earlier.
Yes, everybody enjoy, please. Be safe.
Yes,
Have a great week, everybody. Thank you.
you too.
Thanks.
Hmm.